Guatemala claims half this country. Right now, November 2025, the International Court of Justice is hearing oral arguments. The ruling comes in 2027. I analyzed 3 past ICJ border rulings to see what the court actually does when countries claim colonial treaties should be void. The precedent points towards one likely outcome. The ICJ will probably confirm Belize's boundary. But the legal reasoning matters, and neither Guatemala nor Belize is seeing this clearly. Let me show you the 3 precedents, then the historical twist that makes Guatemala's claim even weaker than it looks. The dispute comes down to one treaty clause. In 1859, Britain and Guatemala signed the Wyke-Aycinena Treaty. Article 1 established the boundary with specific coordinates, rivers and geographic features. Article 7 said Britain would use best efforts to help build a road from Guatemala City to the Atlantic coast. Britain never built it. Guatemala filed their ICJ memorial in December 2020, arguing no road means the treaty is void. Belize filed a counter-memorial in June 2022 that argues that the road clause was separate from the boundary. This means, according to Belize, that a breach of Article 7 doesn't void Article 1. The legal test comes from the Vienna Convention on the Law of Treaties, Article 60. This is the international law rulebook for when one country can cancel a treaty because the other side broke it. A material breach is a violation of a provision essential to the accomplishment of the object or purpose of the treaty. In other words, was the promise so central to the deal that breaking it destroys the whole argument? So, was that road essential to the treaty's purpose? 3 ICJ cases might give us the answer. Cameroon v. Nigeria, 2002. Nigeria had controlled the Bakassi Peninsula for decades with effective administration, security forces and infrastructure. The peninsula sits at the mouth of the Cross River, a strategic location with rich fishing grounds and potential oil deposits. Nigeria's military was stationed there, and their civilians lived there. Cameroon invoked the colonial treaty, the 1913 Anglo-German Agreement. That treaty drew the boundary between British Nigeria and German Cameroon, and it placed Bakassi on the Cameroon side. The ICJ ruled the colonial treaty superseded Nigeria's possession. The principle, iuti possidetis iuris. Colonial boundaries inherited at independence become permanent international frontiers. Its obvious purpose is to prevent fratricidal struggles provoked by the challenging of frontiers. Translation: the ICJ wants to prevent wars between neighboring countries fighting over where borders should be. Keep the colonial lines stable so nations don't kill each other over boundary disputes. Nigeria lost despite decades of occupation. The legal title beat possession. For Belize, this cuts both ways. If the 1859 treaty is valid, Belize has the legal title. If the treaty is void, possession alone might not save them. Treaties matter more than occupation. The Gabčíkovo-Nagymaros project, Hungary versus Slovakia in 1997. This is the smoking gun for Guatemala's material breach argument. In 1977, Hungary and Slovakia, then both under Soviet influence, signed a treaty to build a massive joint dam and hydroelectric project on the Danube River, multi-billion-dollar infrastructure, locks, reservoirs and power plants. Each side was supposed to build specific components on their territory. By 1989, Hungary suspended work, citing environmental concerns. Slovakia said, "Fine, we'll build a modified version ourselves," and diverted the Danube unilaterally. Both sides breached the treaty. Hungary didn't fulfill its construction obligations. Slovakia violated the treaty by altering the project without consent. The ICJ ruled the treaty was not to be terminated. Reading from the judgment, the court would set a precedent with disturbing implications for treaty relations if it were to conclude that a treaty enforced between states, which the parties have implemented in considerable measure and at great cost over a period of years, might be unilaterally set aside on grounds of reciprocal non-compliance. In simpler terms, if we let countries walk away from treaties they've already spent billions implementing, just because both sides violated parts of it, no one would trust international agreements anymore. The court won't destroy treaty stability over mutual breaches. Even a total collapse of a joint mega-project didn't terminate the treaty. If the total failure of a billion-dollar dam project wasn't a material breach, what chance does an unfilled road promise have? Temple of Preah Vihear, Cambodia v Thailand, 1962. France and Siam, Thailand's old name, drew their colonial boundary in 1907. A commission produced detailed maps showing the Preah Vihear temple on the Cambodian side. Thailand received those maps and didn't object. For 50 years, Thai officials used them, didn't contest them, and even acknowledged Cambodian sovereignty over the temple in diplomatic exchanges. Then, in 1954, Thailand occupied the temple. Cambodia sued. Thailand's argument: the maps were wrong, the treaty said the border follows the watershed line, and that would put the temple on our side. The ICJ ruled against Thailand. Here's the key line. Thailand, by her conduct, is precluded from asserting that she did not accept the frontier line shown on the map. In other words, you can't accept the boundary for 50 years, then suddenly claim it was wrong the whole time. This is the Estoppel principle. Your own conduct can stop you from making a legal claim. The parallel to Belize: Guatemala marked boundary points from 1859 to 1939. They cooperated in boundary administration, recognized British Honduras on official maps, and engaged in cross-border relations. 80 years of accepting that boundary. If Thailand's 50 years of acceptance barred their claim, Guatemala's 80 years is even more damaging to their case. One more thing, the ICJ doesn't follow strict precedent like common law courts. Each case is decided on unique facts, but these three rulings show how the court applies the material breach test and treats colonial boundary treaties. Article 38 of the ICJ statute. The court applies international conventions first, then customary law, then general principles. Not fairness, not political preference, just pure law. In 1859, Britain controlled what's now Belize, called British Honduras. Guatemala had separated from Spain in 1821 and claimed the territory based on inherited Spanish colonial sovereignty. The two countries signed the Wyke-Aycinena Treaty to settle it. Article 1 created the boundary, Article 7 said Britain would use best efforts to build that road. Britain rejected Guatemala's road demands, saying best efforts wasn't a binding obligation. Guatemala protested, but here's what they did for the next 80 years. They accepted the boundary in practice. In 1931, Guatemalan officials physically went out and helped mark boundary points on the ground, like the Garbets Falls and Gracias a Dios Falls. From 1859 to 1939, Guatemala cooperated in marking that boundary, recognized British Honduras on official maps, and engaged in border administration. For 80 years they treated that boundary as legitimate. If your government cooperated in marking boundary points, recognized the territory on official maps, and administered the border for 80 years, how do you argue in 2020 that the treaty creating that boundary was invalid from the start? That's the Estoppel principle from the Temple case, and Guatemala's 80 years makes their position even weaker than Thailand's 50. So what will the ICJ likely do? Based on the three precedents, here are the outcomes ranked by probability. Outcome 1. Full affirmation of Belize's territory. Based on ICJ patterns in numerous territorial cases, this is the most likely outcome. I'm citing the Libya-Chad principle from a 1994 case. Once agreed, the boundary stands. For any other approach would vitiate the fundamental principle of the stability of boundaries. Guatemala's material breach argument faces the Gabčíkovo-Nagymaros bar. The Estoppel problem is severe, and Iutu Possedius Juris favors confirming colonial boundaries. Outcome 2. Compensation declaration. The ICJ could rule Britain breached Article 7, but the boundary stands with possible compensation to Guatemala for the unfulfilled road promise. The estimated value in 1859 terms would be significant in today's currency. That claim would be against the UK as the predecessor state, not necessarily Belize. Outcome 3. Territorial transfer to Guatemala. This would require the court to overturn Iutu Possedius Juris boundary stability and the Gabčíkovo-Nagymaros material breach standard, Guatemala has had zero effective control of the claimed territory. Based on precedent, this is highly improbable, but the ICJ decides each case on its specific facts. These patterns aren't guarantees. So let me bring it back to where we started. When Guatemala assumes the ICJ will restore their sovereignty, they're ignoring 3 cases where colonial treaties stood, despite breach claims, and 80 years of their own conduct accepting that boundary. When Belize assumes their border is completely safe, they're ignoring that the ICJ has offered compensation in split decisions before. The evidence shows the ICJ applies law, the Vienna Convention material breach test, iuti possedis juris, and treaty stability. Both narratives erase how international courts actually work. And when this ruling comes out in 2027, thousands of Maya people will still have had zero say in a process deciding whether their homeland gets divided. Subscribe for more evidence-based analysis, and let me know what topic I should tackle next.